Hey guys, my name is Shashwat and I'm a legal intern at LEXIS and Company. In this video, I will be talking about the concept of strict liability and absolute liability under the law of torts. So, let's start with the strict liability. The principle of strict liability evolved in the case of Ryland versus Fletcher in the year 1868. The principle of strict liability states that any person who keeps hazardous substances on his premises will be held responsible if such substance escapes the premises and causes any damage. Going into the fact of this case, the Fletcher had a mill on his land, and to power the mill, Fletcher built a reservoir on his land. Due to some accident, the water from the reservoir flooded the coal mines owned by Rylands. Subsequently, Ryland filed a suit case against Fletcher. The court held that the defendant built the reservoir at his risk, and in course of it, Fletcher, if any accident happens, then the defendant will be liable for the accident and for the escape of the material out of his premises. Going by the principle laid in this case, it can be said that if a person brings on his lands and keeps some dangerous things, and such thing is likely to cause damage if it escapes, then such person will be answerable for the damage caused to the other person or state or anything. The person whose property such a substance escaped will be held accountable even when he hasn't been negligent and in keeping the substance in his premises. The liability is imposed on his part, but the substance kept on the premises is hazardous and dangerous. There are some essential conditions which should be fulfilled to categorize a legal for liability under the head of strict liability. The essentials are that it is a dangerous substance, then secondly it escapes, and thirdly it is of non-natural use. Then comes the absolute liability. In the rule of absolute liability, in simpler words, can be defined as the rule of strict liability minus the exception. In India, the absolute liability in the case of MC Mehta versus Union of India. This is one of the most landmark judgment related to the concept of absolute liability. I forgot to mention the exceptions of strict liability. That is, if it is the plaintiff's fault or the act of God or it is the act of any third party, then the strict liability won't happen in these types of cases. So let's continue with the absolute liability. The facts of the case MC Mehta versus Union of India are that some oleum gas leaked in particular area in Delhi from industry due to leakage, and many people were affected. The Supreme Court then evolved the rule of absolute liability on the rule of strict liability and stated that the defendant would be liable for the damage caused without considering the exceptions to the strict liability rule. According to the rule of absolute liability, if any person is engaged in an inherently dangerous or hazardous activity and if any harm is caused to the person due to any accident which occurred during carrying out such inherently dangerous and hazardous activity, then the person who is carrying out such activity will be held absolutely liable. The exception of the strict liability rule also wouldn't be considered in such type of case. The rule laid down in the case of MC Mehta versus Union of India was also followed by the Supreme Court while deciding the case of Bhopal gas tragedy. To ensure that victims of such accidents get quick relief through insurance, the Indian legislature passed the Public Liability Insurance Act in 1991 and was very helpful to the common people. I may conclude by saying that the rule of strict liability and absolute liability can be seen as exceptions. A person is made liable only when he is at fault, but the principle governing these two rules is that a person can be liable even without his fault. This is also known as the principle of no fault liability.